these cases?
Yeah, I believe all these cases are similarly situated. Oftentimes, judges will consolidate these cases even if a defense attorney files a bifurcation motion to keep each and every charge independent or complaining witness independent from one another. But it definitely bolsters the prosecution's case in chief because they would not normally get a guilty verdict if it wasn't for all these witnesses who don't know each other, all testifying to similar conduct that occurred to them with the same defendant. It's definitely a blow to the defense attorneys in this case. I know that was kind of a pivotal moment for the defense attorneys because I believe if they were to make this argument that the case should be bifurcated, they could have independent trials, independent opening statements, independent cross-examinations without the fear that they're going to look at this case in the totality of circumstances, which is going to be very important for the defense attorneys to keep the jurors' minds independent per complaining witness when they testify. And that's really what the case is going to come down to. I know that the prosecution knows their case is weak without having all of these witnesses consolidated in this case for one trial. The bifurcation motions are hard to win. I've seldomly had a judge rule that these cases that are similarly situated should be tried separately. And in this case in particular, there's way too much information, especially the relatability for the offenses to have independent trials for them.
Right. Well, we do know that the defense is going to try and chip away at the credibility of each accuser one by one. But of course, the one defense we know they're going to be using is consent because obviously there's DNA involved, so you can't argue anything else but that. So with that in mind, do you believe there's no other way around getting Winslow on the stand?
Well, the consent argument is going to be Winslow's strongest approach because they're not going to be utilizing CTE. That's not a defense that they're going to be going with. Obviously, we know these encounters did in fact occur, especially with the strong evidence that's irrefutable, the DNA evidence that we're going to see at the trial level. But yeah, it's one of those things where they will have to call Kellen Winslow to the stand, and it may be in his best interest because of the consent element that they're arguing as an affirmative defense in this case. But however, it's going to be a strategic approach because now you're leaving them vulnerable and open to the prosecution's cross-examination, which ultimately is going to bring in potentially other acts, other bad conduct that he may not necessarily provide that information in his direct, but it does open up Pandora's box regarding other conduct that he may be involved in. So it's really going to be a strategic approach based off of the defense attorneys in this case.
Incredible. All right, criminal defense attorney Vic Monder out in San Diego. Thank you so much. All right, coming up, Judge Bowman explains why he allowed all of the Jane Doe cases in the same trial. It's a very important ruling. Stay with us here on Court TV Live.